In Kenya, for the longest time, the role of the victims of crime in the criminal justice system had been a peripheral one. The victim had restricted influence over whatever the progress the matter would take. A new dawn for restorative and reparative criminal justice in Kenya came when President signed into law the Victim Protection Act 2014.
The Victim Protection Act was enacted in 2014 for the purpose of actualizing Article 59 of the Constitution. Article 59 provides for the promotion and protection of victim rights. So I feel like this is something that goes unnoticed, but it's actually one of the articles in the Constitution that is very progressive. In Africa, the only other country that has a mechanism for victim protection is South Africa, and it's not even as detailed as what we have. Our act actually is more domesticated and provides for more things than even the International Criminal Court's provisions for victims. So I think kudos to the 2010 Constitution. This is somewhere that they really tapped properly, and I must say I'm privileged to have been part of implementing this act. The core mandate of the Act, of course, there are provisions under the Act on what should be done, being, of course, the promotion and protection of victim rights. But I think one of the things that I would like really brought forward is understanding that the purpose of the Act has stipulated. One of it is to ensure that there's protection of dignity of victims. We have a clause under the Constitution that talks about every person having an inherent right to the protection of their dignity. But this is an act that has actually actualized that and taken it in and specifically provided for it in the understanding that once an offense is committed to someone, some of the things, especially like those people who go through sexual offenses, having your dignity protected is a core value that you'd always want in the system. I think another thing that makes me proud about this act is the fact that it also provides for the promotion of the dignity of the victim, but also having the purpose of ensuring that we can have mechanisms for resolution that are not just court-based.
Who is a victim of crime?
The act has been very kind as it has provided a very wide definition of victim, being any person who has, any natural person who has suffered any loss from or damage from crime. So for us as the board, as we implement this act, we look at it as any person, anyone who has been affected by an offense recognized under law. So you can imagine all the offenses that are there in the penal code, having however far you're removed, whether you're the immediate person or far, the act provides that you actually are protected under this act and are required to be protected to different extents, and there are certain rights that accrue to you as a victim of any crime in this country. So I think that is very important. It gives us a starting point of how the public relates with the act and basically this the board, the Victim Protection Board.
The Victim Protection Board, therefore, is very pivotal in ensuring that concepts of restorative justice, restitution and compensation as a means of providing Kenyan society true justice are upheld.
The Victim Protection Board is one of the departments that is housed at the AG's office in the Department of Justice. It has been around for about 4 to 5 years from the enactment of the Victim Protection Act in 2014. So yeah, this is where we're at now. One of the things that I hope we'll be able to look through is the functions of the act. The functions that the board has been charged with ensuring happen. It's in promotion and protection of victim services. Now, what does this mean? Those functions could be anything. They're diverse. It's promoting the right to access to information. It's promoting rights to protection, promoting your rights to trial. There are so many different functions that are provided for under the Constitution. Under the Act, but one of the things that the board was mandated with was to actually create a rights charter. So if you're able to read through the Act, which most members of the public will not know, is that it provides for all these fancy things and promotion and protection of rights. But then what are these rights? Me as a Kenyan, when I'm sitting at home and something happens to me, and I go and report an offense, what do I know or understand are the rights that I am supposed to have? So as a victim, as we've said, you become a victim the moment you suffer damage from any loss. So as a victim, the moment a crime has happened to you, you have certain rights, and those rights the board has actually stipulated it down in what we refer to as the Rights Charter. So the Rights Charter is a document that we had to come up with. It was provided for in the Act to actually demystify and explain what those rights are. So from the Rights Charter, you'll understand we have a victim is entitled to information. It explains to you what that information is, who you're supposed to be getting it from, when, where. When you say that a victim is entitled to process in trial, participating in trial, what is that? What is a trial? When does it start? When does it end? How do I participate as a victim? What does that mean when I sit in court as a victim? The Charter gives you that information. When you talk about a victim has a right to protection, what is that? What is protection? Is it like witness protection and accused person? Is it witnesses? How do we break that down for me to understand the kind of protections I need? When we say a victim has a right to psychosocial support, what is it? Is it counseling? Is it medical health care? Is it transport? Is it education? What is it that you're required to get as a victim? So we have the Rights Charter that speaks specifically to the rights that are there for you as a victim. That is the starting point. It's one of the things that I'm really proud of as the board, of having been able to draft that document, having the same enacted, and as we speak now, we're just waiting for the launch of the document.
The Act has enabled a more friendly and receptive justice system for the victims of crime by looking beyond just pushing and reforming the wrongdoers.
I think maybe this takes us back to the history of our justice system. We have a very adversarial process, and most of the time, the people whose rights have been accommodated in the justice system and even in the Constitution have been the accused person. So it has always come from the point that what we call in law, he who alleges has to prove, but then he who alleges is not given any protections or rights. And why it's important to emphasize on the victim, especially if you look at it in trial.
The Act and the Victim Protection Board will consequently go a long way in improving the lives of victims of crime. At this point, then, the most important question is, how has the Victim Protection Board ensured that the Act is implemented and the victims benefited?
We can talk about the cases, which is well and good, but I feel like we are limiting the accomplishments of the board to cases alone, which is not just the core mandate of the board. One of the most important mandates of the board is coordination. So in as much as the board has the specific duties to actually give services and disseminate information in a specific way, the board has also the very core mandate of coordinating victim services. And I think this was one of the purposes of the Act. I'll give an illustration. We have victim services under the Office of the ODPP. We have victim services in the Office of Child Protection. We have victim services with the police. We have, like, every department or every ministry organization, especially within the justice sector, has victim services. So we coordinate that. So instead of having reputation and spending more resources, we coordinate those activities. One of our, since you asked about the cases, one of our, I think one of the people who have really supported as institutions has been the judiciary. They have really embraced the Victim Protection Act, and they've been able to implement it. We've had, I think, the beginning case that actually set the pace for victim protection, and with the judiciary, it's limited in participation at trial. The one that really sets the pace is the case of Honorable Gideon Mwiti Iria. I don't know if you recall this case about the MP who was alleged to have abused a lady in an office in Westlands. So this case really brought out the victim participation in court at the first instance. So the victim lawyer at the time was seeking to be supplied with certain evidence in the court, and of course there was uproar, like, who are you? The court is for the prosecutor and the accused advocate. Who are you? And you see, at least that set the pace, because the court spoke about the Victim Act and the rights, and at that time the court allowed the victim to participate to the extent of addressing the court on issues of law. So that has evolved. That was years back. Then we went ahead, we had the case of I think I'll speak to Boniface Mololo. Boniface Mololo is actually a case that I did within I think it was like 3 or 4 years back. The case was the first one in which a victim advocate representing the victim was allowed to do a revision with the court. To apply a revision. A revision is where you want to have a change of an order that was issued. So the lower court had issued an order disallowing DNA application by the victim. So because we were not satisfied, we went ahead and requested did a review with the High Court, and the High Court reversed those orders and said, yes, the victim is entitled to participate, and not only participate, they're entitled to these orders because they've given proper grounds. From there, of course, the accused person objected. We advanced to the Court of Appeal, and the Court of Appeal actually entrenched and really spoke about the victim advocates and said they're entitled to participate to this extent and gave us their orders. The reason this is a critical fact because it is not an application brought in by the normal prosecutor or the accused person. This was done by the victim lawyer in their standing as a representative of the victim. So these things have shifted the dynamics on how trial is done. I think one of the cases that you would recognize and know that is important, maybe familiar even, is the case of Nashon Mutua, which we usually refer to as the case of Willie, the advocate and the tout, and the advocate and the client and the taxi driver who were murdered. Actually now stipulated participation in court because it's the case that allowed the victim advocate to actually cross-examine witnesses. Has never happened before. And as I said from the beginning, the first time we were allowed to, as victims, to address the court was on issues of law. So it's evolving. Now we got to the point where they were actually allowed to cross-examine witnesses, which is a key shift in the dynamics of how litigation and criminal processes are done in the country. I think we are seeing the judiciary doing very well. I think the last one, and maybe the most popular one that I would like to touch on, was on the case of Babu Owino. That one I know caused a lot of controversy, but sideshows aside, I think the fact that the court looked at the victim's needs, looked at the victim's condition, and incorporated it in setting the bail for the accused, even before we went to trial, and ordering that the accused pays medical upkeep and fees for the victim, is very critical. It does not happen. We might say it was not right or what, but because as a victim, at the end of the day, we are seeing the judiciary embracing more and more the participation of victims. And this is what we are trying to cut across within the justice system. So we've had a lot of interactions also with the Office of the DPP. They might not be apparent, but the fact that the prosecutor can stand at one point and the victim advocate stand, and there's no clash, and no one is claiming that we are usurping the ODPP's role, I think we have come a long way. Everyone understanding where the limitations are and how to work in court with each other has come a long way. The same thing has happened with police officers. I remember some time back trying to get information from the police as a lawyer, and they ask you, where Nani, who are you? And you're like, but I'm the victim advocate. And they're like, no, go get an order or come with the accused person or whoever, which was very difficult in terms of accessing information and being a participant in the process. So the fact that we actually see police understanding, okay, there's also a lawyer for the victim. So it's not just the prosecutor, and they can actually make the files in 3 copies, prosecutor, accused, and victim, is advancement.
Other than these functions, the board has been playing a critical role in coordination of key stakeholders in understanding the act and the role of the victims in the justice system.
I must say, in terms of coordination, the board has done very well in sensitizing the people within the justice system. We've had a lot of support from the civil society. We've had a lot of support from the CBOs, the community-based organizations, and just having members of the public understanding, yes, there's this thing that is happening that is new, that is shifting the climate of the justice system. I think one of the things I need to just touch on would be the NCAJ. The NCAJ is a body that coordinates the justice sector reforms, anything related to the justice system. And we say as a board, we are happy that we've been involved with some of the committees therein. So I think we are doing a lot, not just cases. Cases is one aspect, but victims start from the time you go to the police or the chief or whoever it is, the authority that you report to the time a person is convicted or rehabilitated. So all these people who you interact with as a victim are part of our stakeholders, and we have an obligation to actually work with them and sensitize them on what victims' needs are.
Now that the role of the victim in the justice system is clear, other justice actors understand that the victim is present and the mechanisms that make the victim feel that they are getting justice are in place. The ball now rests with the victims to step up and demand for what is rightfully theirs.
I hope members of the public will understand. I know there might be the urge to come all and say that we have been compensated and we found guilty and we want this. Also understand our act begins from 2014. So we are looking at victims from 2014 who experienced crime from 2014 to date. And we have mechanisms of determining what gets paid, how it gets paid, who gets which services. So that is something that we need to understand. I know one of the other things that has been a bit problematic is the confusion between victim compensation and the reparations, and the committee that came after the TGRC. I'm sure you'll be able to understand from other officers within the AG's office. Those are two different things. So the victim will be looking at victims of crime from 2014, issues of reparations or things coming out of the TGRC report. I'm sure you speak to other people and there are mechanisms to that. So I hope we'll just find an exercise and a place that we can harmonize and work well with all the actors who are relevant. We don't charge. Oh my gosh, we don't charge. In fact, if you're charged, that is also a mechanism of complaint. If you're charged by anyone for anything that you're not supposed to be charged, complain. Even the P3 filling, please understand, you do not need to pay for the P3. You can complain. So, no, we don't charge as a board. That is why it's there. We cannot be charging people who already suffered, and that's not how the board works. You come, you give your explanation, you give your complaint, or you give a request for the assistance you want or need, and then we follow the proper procedures set, of course, within the resources available, and then we give you the services that we can. We don't charge for anything at all. I know we are the AG's office. It might sound scary, but we are not scary at all. There are very good humans in this office. We want you to go to our website. We posted the charter. We posted some of the information on the victim department. See if you can get it. If you cannot get information and maybe you're far away out of Nairobi, we are working together with the Office of the DPP. So if you go to the court, the Office of the DPP, and as a victim and request for assistance, they'll be able to guide you appropriately. Do not feel like you're stuck. If you're in the police and you don't understand, find out. We have telephone numbers of communicating with the office. We might not be present directly, but we can find someone who's where you are to be able to assist you with the information or the things you need. So don't think we are inaccessible. The AG's office is big, has representation in every county. You can actually just go to the AG's office within your county, and they will also be able to guide you. We have resources there and put you in connection with the right people.